Welcome everybody to our webinar today. Today we'll be discussing our webinar, which will be on Ask an Employment Lawyer, Contracts, Performance, and Navigating Dismissals. My name is Sam Andrews. I'm a business development representative here at LegalVision, and my fantastic co-host today is Joel Hayden. Joel is actually a practice leader here at LegalVision, working out of our employment team. Before we begin, everybody, just a couple quick housekeeping items for me to elaborate on. First and foremost, you will be receiving the recording and slides in your email after this webinar is put through. So if you did have to leave early, do know that you will be receiving that one as well. Secondly, you're able to submit your questions in the Q&A box as we go through the webinar today, and we will answer them, and Joel will answer them as we go through. Lastly, please remember to complete the feedback survey after the webinar. We're always working hard here at LegalVision to improve our processes and our webinars for all of you. So if you do get a chance, we'd really appreciate you filling out that survey, which will come through after the webinar's finished. Now, by viewing and joining us today on this webinar, you're eligible to receive a complimentary consultation with us at LegalVision, where we'll discuss how we can help your business. Now, in this consultation, we'll have a chat about your growth plans and how we can set you up for success from a legal perspective. To claim this, it's really easy. Just leave your contact details in that survey I mentioned that appears when the webinar ends. Alternatively, you're able to contact us via our website and we can slot you in for a complimentary consultation with the team. Now, shortly, Joel's going to be joining us and we're going to answer all of your questions. While you submit them, I'm just going to take a moment to tell you about LegalVision's membership. Now, by becoming a member here at LegalVision, your business gets unlimited access to our full service commercial law firm. We have over 100 lawyers here at LegalVision for all of your BAU or business as usual legal needs. We work towards providing ongoing legal support while reducing overall legal spend and maintaining high-level advice. With us, you have access to our affordable and scalable team. It's also powered by industry-leading tech. We have an in-house platform named Prism. With LegalVision, our team is able to assist you with unlimited document drafting and reviewing of all business contracts. Also, unlimited legal advice consultations with our legal team. And also unlimited domestic trademark registrations, and of course, much, much more. As a LegalVision member, you won't have to worry about the cost of lawyers ever again. Think of it as having your own in-house legal counsel, where we'll take care of your business as usual legal work so you can focus on running and growing your business. And if you are in-house counsel and joining us today, we also offer a dedicated service to manage your high volume business as usual legal tasks. Now, to learn more about this membership or desk extension, as we call it, and how it can help you, you can request that free consultation that I mentioned, or that complimentary consultation that I mentioned, when the survey appears at the end of this webinar. All right, Joel's going to join us now and start answering some of those questions.
Thank you very much, Sam. And as Sam just mentioned, everyone, we're doing a bit of a different format today in that we're not just presenting a topic, we're going to be answering some questions that you've got about contracts, performance, and navigating dismissals. And so we do already have a number that have come through that I will get into, but continue to put them into the chat as we go through answering these initial questions, and we'll try to get to as many as we can in the time. So starting off, we've got a question of what should be in the employment contract and what should be in the letter of offer. And so it is important to note the difference between the offer letter and the contract itself, in that the offer letter is normally just an informal document or statement of the terms of the role being offered to an employee. It usually wouldn't be considered a binding legal document. It's more an explanation of the terms that will be in the contract. Sometimes it just attaches the contract itself. The contract obviously is more important here, as that has the operative and binding terms from a legal perspective. So anything important should be included in the contract itself rather than just the offer letter. And really, if you're going to use both of them, and you don't need to, if you do just want to use one document, you can just use the contract. That covers everything off. it doesn't have a nice covering letter then. But if you are going to have an offer letter that does attach the contract or is separate to the contract, you should absolutely ensure that there's no conflict between what the offer letter says and what the contract says. That would create uncertainty, probably going to lead to some type of dispute over the terms at some point. So if you are going to have a description in the offer letter, it is good to include a term that says, to the extent of any difference with the contract itself, that the offer letter won't prevail. It's the terms of the contract that will actually apply. We've also got a question about employment contracts for casual staff and whether they're going to be the same as for your permanent employees. And it is the case that due to the nature of casual employment being quite distinct to permanent employment, that you will see quite a few differences between a precedent permanent employee contract and a casual employee contract. And really any business that is using both categories of employment should have a clearly defined precedent for each of them. There's not really a world where it makes sense or will practically work to have one document, even with some optionality, that would work for both casual employees and permanent employees. And look, that's not to say that a lot of the terms won't be common. Of course, we want to be protecting things like intellectual property and confidential information, regardless of the status of the employment. But casual agreements will differ usually from permanent agreements in that they need to have those clear statements about the fact there's no commitment to ongoing work to ensure it's actually reflective of a casual engagement on the face of it. And there should also be express recognition of a casual loading. And whether that's stated as, the rolled up pay is inclusive of a 25% loading, or it's a 25% loading separately identified, we do want to specifically reference the actual loading in the contract to be sure that we're actually offsetting that obligation under most awards and the national minimum wage clearly. Casual agreements will obviously also not reference things like paid leave, as a casual employee is not entitled to that. And there should be a bit more consideration given to what, if any, restraints should be included in the casual agreement, because really terms like non-competes especially will be very hard to enforce for casual employees due to the ad hoc nature of casual employment not really being in line with a pretty prohibitive restraint like preventing them from working in a similar business. So it's good to be aware that casual agreements will normally be a bit more simple. They'll normally place a bit less obligation on the employee due to the more informal nature of the engagement. So we've got an attendee who's looking to also hire some summer interns, and they're asking what contract should apply to that relationship. And I would say it's important, before you even start looking at specific candidates, to understand what it is the business actually means by an intern. An intern is more of an informal label that could apply to someone being an inexperienced employee, or potentially an unpaid volunteer who is there for work experience. But it is a fact in Australia that employment can be found in reality rather than just what a contract says. So it is vital that you're treating an intern in the right way if you are going to have them as an unpaid intern. Employment is really defined by the worker performing valuable work for the employer in exchange for compensation. And so if an intern is going to be performing productive work for the business, rather than for their own benefit, it's quite likely that they should be classified as an employee, i.e. treat them as if they've got a minimum wage under an award or the Fair Work Act, and treat them like any other employee in the business. They'd normally just be a relatively inexperienced employee. If the nature of the internship is that the employee or worker here is truly going to be receiving the benefit for themselves, i.e. the experience in the industry or the business, they're not going to be doing productive work, then there is a route to having them as an unpaid intern. What you would really want to be certain of is that point that I just mentioned. It's for their benefit rather than the business. And so that would normally look like shadowing work, learning, instead of, say, standing by the photocopier and just doing administrative work for the business's overall goals. If the worker, is going through an university course or similar, there is actually the option to go down the route of having a vocational internship as well. And that is the specific exception under the Fair Work Act for an intern needing to be provided any pay. And so it is actually a safer arrangement. But there should always be an initial task when talking about bringing on an intern. Are they going to be an employee, or are they going to be an unpaid volunteer style intern? And that distinction should be considered quite carefully. If you do get to the point of them being an employee, obviously we'd just expect to see an employment agreement in place, like for any other employee. If you're going down the route of an unpaid intern, in reality, a much more simple document. It would be something that you'd see really just terms relating to confidential information, intellectual property, and some very brief provisions around what the intern will be doing, and normally a statement of, it's for the intern's benefit rather than the company itself. So we have an interesting question for a business that has had a workplace agreement that has expired, and one staff member has not signed a new employment contract, with the question being, do they retain the terms and conditions and benefits of the expired agreement, or do they revert to a modern award, or is a new contract required? This is quite a complex question. So in the specific circumstances, you'd be getting advice very specifically. But generally speaking, a workplace instrument, that's normally a reference to an instrument like an enterprise agreement. It's not going to terminate simply because it has expired. This is a concept that's normally referred to as nominal expiry. And when an agreement is only nominally expired, it still is actually in effect. So if it's just past its nominal expiry and a new contract hasn't been signed, the terms of the agreement will still actually apply on the basis it hasn't actually been terminated. If the instrument that's being talked about here has terminated, then the EA itself would have only applied as a matter of law, normally speaking, unless the employment contract varied that. And where it applies as a matter of law, when that agreement ceases to exist, then it will revert back to the award on the basis that the award will now apply as a matter of law. So nominal expiry, the same agreement will apply. If it's actually terminated, it is likely to have to revert back to the relevant modern award on the basis that it applies by law. But again, that can be quite complicated in the individual circumstances, so a great one to seek specific advice on with a bit more detail. We've also got a question about contracts for contractors. And the general gist of it is, should we still have contracts in place for our contractors compared to our employees, or would it only be for certain jobs where we see it being necessary to have a contract in place? What's the recommendation there? Any lawyer will tell you that any relationship that you have where parties have rights and obligations and it's potentially significant to the business, you should absolutely have a written contract in place. And that is no different at all for contractors compared to employees. It's perhaps even more important for contractors, given there is, in Australia especially, this conflict between employees and contractors and their classification, and a lot of focus on that from regulators, unions, etc., in exploring whether a lot of contractors should be employees in reality. The best starting point for making sure that you have safe contracting relationships is to ensure there is a fulsome contract in place that confines all of the details of the relationship to writing. And no, that isn't a complete answer to the question, in that the Fair Work Act now has a definition of employment that we need to consider, even beyond a contractor agreement. But the starting point is always the agreement itself. And you want to see something in place that looks distinct to an employment agreement and has a clear statement that it's not a relationship of employment. And that puts you in the best position to be able to justify the existence of your contractors and why they're not employees. And these contracts are in the nature of what we call contracts for service, and they should look quite different to an employment agreement, which is a contract of service. It sounds semantic, but it's very well established legal principles that there are a lot of differences between those two types of contracts. And if the lines are blurred, it's quite common for that to cause risk from a classification perspective. So now we're talking about a specific employment clause and whether we should be continuing to include them, set off or offsetting clauses under an employment agreement. And this has been brought to attention recently. There were some decisions in the federal courts around Coles and Woolworths' use of offsetting clauses in contracts. And for people that don't understand what that is, the purpose of an offsetting clause is to allow an employer, with the agreement of an employee, to offset certain modern award entitlements that could include things like weekend loadings, overtime rates, etc., into one all-up rate of pay or salary. And it's very common for employers to use these. Those decisions, the Coles and Woolworths decisions, they didn't eliminate the whole concept of offsetting. The court just didn't agree with the legality of what Coles and Woolworths had been trying to achieve, which was offsetting across multiple pay periods, which in our view has never been likely to be permissible in really any circumstances. And so the answer is you should absolutely still be including offsets in your contracts. They are one of the most important terms an employer should have in their employment agreement. It's obviously particularly important for any workers who are paid a flat rate or a salary, as without it, we don't actually have the agreement from the employee to apply those different entitlements under an award to an all-up salary or rate of pay. And so we absolutely need it to be in there. And what it should look like is specifically calling out the entitlements that it's set off, and it should only seek to set them off within a single pay period. So you don't want to be spanning multiple pay periods and relying on them to offset other pay periods, because that's where Coles and Woolworths got tripped up. That's not something that's permissible. So the advice here is absolutely include it, but just be aware you can only offset within one pay period. If you want to be able to take advantage of that to the maximum extent possible, that would be over monthly pay periods. That's the greatest pay period that's permitted by the Fair Work Act. So absolutely still a must-have in employment agreements. Got another question about casual pay. For award-free casual employees, is there still a need to identify the casual loading? And is there any obligation to pay weekend and after-hour loadings? Assuming, again, for an award-free casual here. So even casuals that aren't award covered will have a loading on the national minimum wage, the typical 25% loading, and that should still be specifically noted in the relevant employment agreement in the way that I mentioned a bit earlier, i.e. specifically calling out whether the rate is including of the 25% or whether the 25% is identified separate to it, next to it. Either way is permissible. We just want to see it actually acknowledged in the contract itself. Like with permanent award-free employees, no different for casuals, there's no specific penalty or overtime rates that are prescribed by law. There won't be any that you find in the Fair Work Act in the same way they're in most modern awards. But it is important to remember that awards do apply to most employees, and an employer can't just deem an employee to be award-free. So always be very careful in making that judgment that a casual might not be covered by an award, because if you cease paying those loadings and things that we're talking about, and you're wrong, that will be a contravention of the relevant award and the Fair Work Act. But if they are genuinely award-free, no, there is no obligation under the Fair Work Act for loadings. There might just be a market need to pay them if employees aren't willing to work the more antisocial hours for the same rate of pay. But that's just subject to whatever the employer can agree with the employee specifically. So we're going quite rapid fire here, but we're going to turn a little bit now to talking about performance and relevant dismissal considerations with some questions we've gotten from that. First, we've got, can an employer introduce KPIs during a contract period? I just understand that to be, can we introduce KPIs separate to the employment contract that we already have in place? And the answer to that is absolutely. And it's actually quite common, I would say more common and more advisable from a legal perspective too, for KPIs to be kept separate from the contract in their entirety, so as to not make it a contractual term that can't be varied unilaterally by the employer. And this is because the imposition of KPIs, any type of metrics or expectations generally, they can be considered more of a direction by the employer, and a direction in relation to the expectation the employer has for its employees. So it's not something that needs to be a contractual term in the same way that you wouldn't necessarily need your policies or commission schemes to be contractual terms. It's something that can be dealt with outside of the contract as a direction and within the discretion of an employer to manage its employees. And this is useful in that it allows an employer to change those KPIs from time to time without needing to vary the whole contract itself. And so, especially for people like in sales roles, you don't want to be issuing a new contract every quarter when KPIs are revised. It's better to deal with it separate to the contract. And so there's a lot more discretion with what an employer can do there, while noting that KPIs should still always be reasonable. If we put KPIs in place that aren't reasonable, essentially we're not going to be able to rely on them as a safe part of a reason for dismissing someone, as it wouldn't have been reasonable for the employee to ever reach that KPI. And this is a related question that's probably got a bit more detail to it than some others we've answered today, but we've got a question that someone is really keen to hear about managing employee performance effectively and navigating dismissals related to that. And so, as I've said with a few other questions, this is a good type of topic to always seek specific advice on. But when we're talking about performance and dismissals and management related to that, we're normally talking about unfair dismissal risk. And I'm sure everyone's heard of unfair dismissal. It's never going to be lawful to dismiss someone for a discriminatory reason or something else that's unlawful. But when we're talking about what actually satisfies an employer that they're not going to unfairly dismiss someone, we're normally talking about having a valid reason and also being procedurally fair to the employee. And this is more applicable for employees outside of their minimum employment period, i.e. people that have access to unfair dismissal. And so when we're talking about performance, the valid reason should obviously relate to the employee not reaching standards expected by an employer. It is, again, something that should be set, because if we have an expectation, we want the employee to understand what that expectation is. We also want to be able to prove that the expectation was communicated and understood by the employee. And so when we're comparing the unfair dismissal protections to this type of scenario, really what we are concerned with is giving an employee a chance to improve. That's how the unfair dismissal protections relate specifically to performance matters. And so it's obviously important that opportunity is provided and documented by an employer, not just to be fair to the employee and give them a real chance to improve, because that is what is required, but also to show that if that is ever challenged at some point in the Fair Work Commission or anywhere else, that it's easily provable the steps that the company did take to give that opportunity to the employee. So some guidance that I would give in these types of scenarios is ensure that clear KPIs and expectations are set, and you don't want them to just be discussions. You want them to be actually documented in a way that the employee can reference them, the employer can reference them, and both parties understand what is expected of the employee. There's also a real need to address performance issues when they arise. It can sometimes be the easier route to let little issues go, sometimes even slightly bigger issues. And when it sort of reaches a head 6 months down the track and the performance still hasn't improved, that's when it starts to be addressed. You're really setting yourself up to have a harder time to safely deal with those concerns if you're not addressing them when they arise. And this also goes for issues of misconduct. If you let something go as an employer, it can be seen by tribunals and courts as authorizing that behavior, and then it's harder to rely on it at a later date. So ensure that issues, including performance issues, are addressed when they arise, not left to be historical matters that are raised when it all gets even worse at a later date. And where there has been a period of poor performance and the company is concerned that it may be heading towards a route where dismissal may need to be considered, unfortunately, we've all heard of a PIP, a performance improvement plan or performance management plan. They are useful tools for a reason, in that we want to make sure that if we're at the crunch time of actually considering whether an employee is suitable to be ongoing in the role, the employee does need to be aware of that expressly. And so that's normally the purpose of the PIP, putting in place expectations and timeframes and support to try to achieve it, but the employee understanding the potential implications if they don't reach the expectations set by the PIP itself. So again, a really good one to seek specific advice on, but always think about these performance issues as, if they've got access to unfair dismissal, we want to make sure that we are giving them an opportunity to improve legitimately, not just a show process where we're going to dismiss them either way, a genuine chance to improve that has been documented. And if they do improve, that's great. You've got a well-improving employee within your business again. If not, then you'll be in a better position to consider options as far as their employment is concerned. We've got a question now on navigating dismissals for employees where there's only a verbal contract in place. And this is probably a good question before we jump into the specifics to mention the importance of having a written contract in place with all employees, because if you don't have a written contract in place, it's not that you have no contract in place, it's that you might have a verbal contract, you might even have an implied contract based on what the parties almost agreed to or what they've actually done in carrying out the employment relationship. So it's not that there's no contract in existence, it's that you need to consider what the terms of this contract that have no written terms may involve, which is a very tricky question. Tribunals and courts struggle with it, so dealing with it as an employer on a day-to-day basis is much more difficult. And so while it's not a requirement by law in Australia like it is in some other countries like New Zealand, having a written contract in place will avoid a lot of disputes caused by uncertainty. And, it can really relate to anything such as notice periods, agreed rates and hours of pay, as well as the actual category of type of employment the employee falls into. We've seen a number of disputes where someone's really unsure whether they're casual or permanent, and that can lead to disputes over entitlements like annual leave, paid personal leave that only one of those categories get. So really important to have the contract in place in writing. And almost most importantly, as I mentioned a few questions ago, if you don't have a written agreement in place to offset award entitlements, it is incredibly unlikely that you will be able to prove to a court that that agreement existed. And it's likely that you would breach award terms if those entitlements weren't paid as separately identifiable amounts. So I know that was a bit of a preamble to the actual question, but I do want to stress the importance of a written contract. For navigating a dismissal for someone under a verbal contract, it wouldn't change the approach as far as addressing performance or addressing misconduct in the role. You would still be issuing warnings where it's serious, proceeding down dismissal routes. What may be a bit trickier compared to other employees is what is the notice period to be provided if you do dismiss an employee, because normally it's the contract that confirms that. The Fair Work Act itself has minimum notice requirements. There are some streams of case law that have said it's actually a reasonable notice requirement if there's no written contract. But more recently, you would just be relying on the minimum terms provided by the Act as the periods of notice that you would be providing. So just applying that sliding scale based on the actual service that the employee has with the business. So another dismissal related question now, and it's what is considered an appropriate amount of warnings before you dismiss someone? And there's no set rule for this based on conduct and performance issues. It's always about weighing the severity of conduct in light of prior warnings. And you've probably all heard at some point of this sort of myth that it needs to be 3 warnings and then you're out. That's not the way it actually works by law. That's just a policy that can be adopted by employers. And if you do have a policy in place that's quite prescriptive about how to deal with warnings, The important thing is to follow the policy. If you don't like your policy, amend your policy. But while it's in place, you should follow the rules of your policy. Otherwise, it's probably going to be procedurally unfair if you dismiss an employee in relation to matters not covered by the policy. But where you don't have that in place, it's really a judgment of what does the issue actually call for. There are obviously misconduct issues that can give rise to immediate termination. You certainly wouldn't be looking back at, whether warnings were provided if it's serious conduct such as sexual harassment or anything that causes a risk to the safety of another employee. That would just be grounds for dismissal in almost all circumstances. If it's lower level conduct, like being late to work regularly, it probably is necessary to put a few warnings in place to deal with the fact it's a more minor issue. That type of matter might actually be, well addressed by having 3 warnings and then proceeding to a dismissal, given it's not an overly serious issue, depending on the job concerned. So it is always about making a judgment call on how serious is it compared to the harshness of actually letting an employee go. And again, another good one for specific advice in the circumstances. So we've also got a question on how the size of a company, the headcount, can affect termination obligations. So a lot of you are probably aware that there is a concept of a small business employer under the Fair Work Act, and that will be when someone has 14 or fewer employees, and that includes all permanent staff as well as any regular and systematic casuals. So don't forget to include long-term casuals that have been working consistently with the business. That is a bit of a pitfall from time to time. Beyond that, there is actually a unique objection to unfair dismissal applications for small business employers that lowers the bar for the procedure associated with the dismissal. So what we were just talking about with, formality in managing performance improvement processes over a certain period, that's for full-size employers, i.e. 15 or over employees. The Small Business Fair Dismissal Code applies to small business employers. And what that says about performance is that as long as you've raised the performance issues in the past and given the employee a chance to improve, even if it's in an informal way, that will be considered to not be an unfair dismissal for small businesses. There's also a related provision under the code for serious misconduct, which says that if an employer is reasonably aware of conduct that they think amounts to serious misconduct, they'll be entitled to summarily dismiss the employee. Just again, a lowering of the bar in that a little bit of procedure is taken out in recognition of the fact that small businesses normally aren't as well resourced as large businesses and normally won't be able to justify long performance management processes, for example. One of the criteria in assessing what actually amounts to an unfair dismissal is also concerned with the size of the business. And this isn't just tied to whether you're a small business or not. It's effectively a judgment of, is the employer well resourced enough that they should take more care when dismissing an employee? The commission member will consider that when considering an unfair dismissal application. Just looking at some new. So we've got a follow-up question on what we were talking about a bit earlier around vocational interns. What's the actual definition of that? So as I said a bit earlier, this is a concept under the Fair Work Act, and that vocational definition, it needs to be someone who is not being paid for the internship, and it needs to be subject to a requirement of a tertiary course or similar. And so that's think of a university course that has a requirement that someone gets some experience with a business in a certain industry. If they come to you and say, I've got this degree that I'm working on, I would like to get an internship with you, it's subject to this course, you can put them quite safely on a vocational internship. That excludes them from the definition of employment under the Fair Work Act and is a much safer route than just having an unpaid intern who is not a vocational intern. We've also got a question here that's a good one on if there is a clause within the agreement that the employee can be terminated at any time, does this override standard employee conditions as per the Fair Work Act? The answer to that is no, but you still see almost every employment agreement with that standard termination for convenience clause. And that's just to say that under the contract, there's no conditionality to terminating the employee's contract. Statute, legislation, this all overrides contract. And so in Australia, like most countries, even though you see these contractual terms, there's still these statutory protections like unfair dismissal, like the general protections, like discrimination provisions that still need to be considered in exercising that right. So if you terminate the contract in accordance with the contract, no, you're not going to breach the contract, but you do need to be aware of the statutory provisions that protect employees in the country, as that is where the source of protection comes from in Australia, not the contract itself, it's the legislation. And we've got a question on restraints. Restraint clauses in contracts, are they legally enforceable? The answer is sometimes. When we're talking about more common restraints like non-solicitation of employees and clients, they can be quite enforceable depending on whether they've been drafted reasonably. It is much harder to enforce non-compete obligations, i.e. preventing them from setting up a business or going to a competitive business, as courts really do not like the way they prevent an individual from being able to pursue their chosen trade. Non-competes are really going out of fashion in a few different countries, and Australia appears to be headed that way as well. So I would not be surprised if later this year, probably actually next year now, we'll start to see some legislation tabled for consideration around probably restricting non-competes to employees above the high income threshold. But for now, they are still permissible. Just think of non-competes as really only being enforceable for very high-level employees. Non-solicits, etc., are more enforceable for most employees. So I've got a question about fixed-term contracts and whether you can terminate an employee earlier than the end of the term or reduce their hours. A true fixed-term contract has no ability to terminate for convenience, like we were just talking about with notice periods compared to statute. So a true fixed term contract, that would only be able to be terminated for cause, i.e. if the employee breaches the contract itself. That's why it is much more common to see what is called a maximum term agreement. And what a maximum term agreement is that yes, it operates for a fixed term, it might be a year, but there is still the termination for convenience clause in it. So if, for example, there was some reason that the employer did need to terminate the employee under the maximum term agreement earlier, they would still be able to do that without breaching the contract itself. And so that is a good way out, that it would be lawful under the contract. If it's not exercised, then the contract itself would still end at the end of the maximum term noted in the agreement. Got a question. If an employee has lodged a workplace grievance, is there any obligation to place that employee on paid special leave while the grievance is being investigated, settled? No, unless there's no lawful requirement to do this. What's much more common in the scenario is if someone has lodged a grievance against someone else and the allegation concerns serious matters, for example, conduct that could represent risk to other employees, it's actually common to stand down the respondent to the allegation, still on paid leave, while the investigation can be conducted in a fair way, ensuring that, one, if the allegation is true, that they're not representing a risk to the rest of the business, while still ensuring they're paid on the basis that this is an investigation, which means it hasn't been factually settled what did occur. So out of fairness, the employee should still be paid for their time. So it's much more common for a respondent to an allegation to be put on paid leave during that time. But an employer may also consider doing it for the person that has lodged the grievance if, for example, it's affected them significantly and we don't want to be harsh in requiring them to use annual leave or their normal paid personal leave for that period. It's a call for the employer to make, though. We've got a question about whether an employee on maternity leave, whether there is a circumstance where they could legally be made redundant. And the answer to that is yes. It just can't be because they are on maternity leave. That would be a breach of the general protections of the Fair Work Act, probably discrimination legislation as well. But if, for example, the business is undertaking a genuine restructure and that's resulting in the role that the person on parental leave was in and would be returning to, not only is there an obligation to consult under modern awards in relation to establishing a genuine redundancy, there would also be an obligation under the parental leave provisions to consult with them in relation to their role no longer existing. So again, the answer is yes. It will be slightly trickier as there are more red flags around the parental leave, the pregnancy, the carer's responsibilities. But if it's genuinely about the need for the redundancy and it's carried out with proper consultation, it is achievable. A great one for specific advice. So we've got one more question here before we move on. We've had an employee who had poor performance. Performance management was commenced, and then they've decided to go on a period of annual leave and long service leave for a period of months. Obviously, the effect there is that has frustrated the performance management. And so it is important to know that requests for annual leave and long service leave, they do need to be agreed to between employee and employer. They can't be unreasonably refused. But at the same time, if someone is doing it to avoid a management process, for example, that would be an excellent time to consider whether it should be refused. Similarly, if we're actually addressing performance management specific criteria, but there is legitimate leave taken that was pre-planned, that shouldn't derail the pre-approved leave. It would really only be if the employee is taking the annual leave, the long service leave, to avoid it. If there is pre-planned leave, although it might be a bit frustrating, the right way to approach that is to pause the performance management plan and simply recommence it at the point that they come back. And that should include a reasonable adjustment of the actual period of the plan. If, for example, say you're measuring sales over a quarter and they're out for half the quarter, that should obviously be accounted for, as it would be unreasonable to not. And that closes off the questions for today. Thank you very much, everyone. And we'll just get Sam back in now to say a few words.
That concludes the main part of our webinar today, everybody, on Ask an Employment Lawyer. I really want to thank Joel very much for taking time out of his day to join. Always really insightful and valuable information. So thank you very much, Joel. Now, you may also find our publication useful. We're always trying to get as much information out there as possible to assist growing businesses. The publication this week is named How to Hire and Inspire. It's a guide for employers on all the essential employment legal needs. Now, we also have an upcoming event, our next webinar. If you are tired of chasing invoices, we have this great webinar coming up named Stop Chasing Unpaid Invoices, Payment Terms That Actually Work. It's going to be run by our highly qualified debt recovery team we have here at LegalVision, and it will be held on the 30th of September. Now, that's a wrap for today. It's all we have time for. Our apologies if we didn't answer any of your questions. However, to get them answered, please submit your details at the end of the webinar through that survey, okay? And we can answer any questions that we didn't get to or Joel wasn't able to get to today. You will also be able to learn more about our membership and how it can help you. So I'm referring to that complimentary consultation there and how it can assist. Please feel free to opt in for that consultation, everybody. We can get an understanding of your business and understanding of your growth plans and how LegalVision can provide a tailored solution. Now, while this webinar is free, of course, we always value your feedback. So please take 30 seconds out of your day to answer that survey at the end, and it will just allow us to continue to improve these webinars and present them to you. Thank you, everybody, very much for joining today.